Rules have different kinds of consequences. There are rules that impose punishments, require payments, require safety steps to be taken, institute procedures, make statements of policy, declare definitions of important concepts, etc. The element identification skill requires you to answer two questions. What is the consequence of the rule you are applying, and what must happen before this consequence will be imposed or go into effect? When you answer the second question, you will have identified the elements of the rule. An element is a portion of a rule that is a precondition of the applicability of the entire rule. If you can show that all of the elements of a rule apply to a fact situation, then the rule itself and its consequence applies. The failure of any one of the elements to apply means that the entire rule cannot apply. When you are examining rules, you will find that they are rarely, if ever, already broken down into elements for you. Element identification is your responsibility. In our earlier discussion of the food co-op example 10 and the weapon example 12, the elements of the rules were relatively short. This is not always so. How long should an element be? This question has no absolute answer. The two main criteria to keep in mind are these. 1. Each element must be a precondition to the consequence of the entire rule, and 2. You should be able to discuss each element separately with relative ease. Let us examine some additional examples. 971.22 Change of place of trial. The defendant may move for a change of the place of trial on the ground that an impartial trial cannot be had in the county. The motion shall be made at the time of arraignment. Step 1 is to break the rule into its elements. The effect or consequence of this rule is to change the place of the trial. Ask yourself what must happen before this consequence will follow. What conditions or preconditions must exist before the result will occur? The answer will provide you with the elements of the rule. 1. Defendant 2 may move for a change of the place of trial 3. On the ground that an impartial trial cannot be had in the county 4. The motion must be made at the time of the arraignment, hence there are 4 elements to 971.22. All 4 must exist before the place of the trial will be moved. Suppose you are analyzing the following statute. 25 to 403. A pharmacist must not sell prescription drugs to a minor. Ask yourself what conditions must exist before 25 to 403 F is. Your answer will consist of its elements. 1. Pharmacist 2 must not sell. 3. Prescription drugs 4. To a minor, no violation exists unless all 4 elements of the statute are established. If, for example, a pharmacist sells simple aspirin, a non-prescription drug, to a minor, he or she has not violated the statute. The third element cannot be established. Hence there is no violation, because one of the element's preconditions cannot be met. For a number of reasons, rules such as statutes and regulations can be difficult to break into elements. For example, the rule may be long, or may contain lists alternatives, exceptions or provisos. Nevertheless, the same process is used. You must take the time to dissect the rule into its component elements. Examine the following rule as we try to identify its elements. S. While representing a client in connection with contemplated or pending litigation, a lawyer shall not advance or guarantee financial assistance to his client, except that a lawyer may advance or guarantee court costs, expenses of investigation, expenses of medical examination, and costs of obtaining and presenting evidence, provided the client remains ultimately liable for such expenses. The elements of 5 are 1. A lawyer 2. Representing a client in connection with contemplated litigation or in connection with pending litigation. 3. Shall not advance financial assistance to his client or guarantee financial assistance to his client, except that the following is proper. A. Lawyer advances or guarantees court costs, or B. Lawyer advances or guarantees expenses of investigation, or C. Lawyer advances or guarantees expenses of medical examination, or D. Lawyer advances or guarantees costs of obtaining and presenting evidence, as long as the client remains ultimately liable for all expenses. AD. When an element is stated in the alternative, list all the alternatives within the same element. Alternatives related to one element should be kept within the phrasing of that element. The same is true of exception or proviso clauses. State them within the relevant element when they are intimately related to the applicability of that element. In our 5 example, the most complicated element is the third 3. It contains lists alternatives, an exception, and a proviso. But they all relate to the same point, the propriety of financial assistance. None of the subdivisions of the third element should be stated as a separate element. Sometimes you must do some unraveling of a rule in order to identify its elements. This certainly had to be done with the third element of 5. Do not be afraid to pick the rule apart in order to cluster its thoughts around unified themes that should stand alone as elements. Diagram the rule for yourself as you examine it. If more than one rule is involved in a statute, regulation, constitutional provision, charter, ordinance, etc., treat one rule at a time. Each rule should have its own elements, and when appropriate, each element should be subdivided into its separate components, as in the third element of 5. Once you have broken the rule down into its elements, you have the structure of the analysis in front of you. Each element becomes a separate section of your analysis. You discuss one element at a time, concentrating on those that pose the greatest difficulties. Element identification has many benefits in the law, as demonstrated in Exhibit 7.1. For example, knowing the elements of rules can help give direction to interviewing and investigation. While performing these tasks, you are often looking for relevant facts. How do you know which facts are relevant? One of the ways is to identify the elements of the potentially applicable rules that both sides may be arguing in litigation. Facts are relevant if they help show that those elements apply or do not apply. As you can see from Exhibit 7.1, element identification will also help identify issues, draft complaints and answers, conduct depositions, organize memos and exam answers, and even charge the jury. To a very large extent, legal analysis proceeds by element analysis. A major characteristic of sloppy legal analysis is that it does not clearly take the reader or listener through the important elements of rules that must be analyzed. Assignment 7.7 Break the following rules into their elements. A 200. Parties to a child custody dispute shall attempt mediation before filing for a custody order from the court. B. 75b. A lawyer shall not enter into a business transaction with a client if they have differing interests therein, and if the client expects the lawyer to exercise his or her professional judgment therein for the protection of the client. C. 38. A person or agency suing or being sued in an official public capacity is not required to execute a bond as a condition for relief under this section unless required by the court in its discretion. D. 1.2 A lawyer may not permit his or her legal assistant to represent a client in litigation or other adversary proceedings, or to perform otherwise prohibited functions, unless authorized by statute, court rule or decision, administrative rule or regulation, or customary practice. D. 179A7. If at any time it is determined that application of best available control technology by 1988 will not assure protection of public water supplies, agricultural and industrial uses, and the protection and propagation of fish, shellfish and wildlife, and allow recreational activities in and on the water, additional effluent limitations must be established to assure attainment or maintenance of water quality. In setting such limitations, EPA, the Environmental Protection Agency, must consider the relationship of the economic and social costs of their achievement, including any economic or social dislocation in the affected community or communities, the social and economic benefits to be obtained, and determine whether or not such effluent limitations can be implemented with available technology or other alternative control strategies. The benefits of element identification. Identifying issues. Once you identify the elements of a rule, the next step is to find the elements that are most likely to be in contention. These elements become the basis of legal issues, as we shall see in the next section. Drafting a complaint. When drafting a legal complaint, you often organize your factual allegations around the elements of each important rule in the controversy. The most important rule is called the cause of action, which is a legally acceptable reason for suing someone. Negligence is an example. Drafting an answer. When drafting an answer to a complaint, you often state your defenses by alleging facts that support the elements of each defense. MZ.NI defenses, such as the statute of limitations, are nothing more than rules designed to defeat the claims of another. Organizing an interview of a client. One of the goals of interviewing a client is to obtain information on facts relevant to each of the elements of the potential causes of action and defenses in the case. Element analysis therefore helps you organize the interview and give it direction. Organizing an investigation. One of the goals of investigation is to obtain information on facts relevant to each of the elements of the potential causes of action and defenses in the case. Element analysis therefore helps you organize the investigation and give it direction. Conducting a deposition. During a deposition, many of the attorney's questions are designed to determine what facts the other side may be able to prove that support the elements of the potential causes of action and defenses in the case. Organizing a memorandum of law. One of the purposes of a memorandum of law is to tell the reader what rules might apply to the case, what elements of these rules might be in contention, and what strategy should be undertaken as a result of this analysis. As we saw earlier, a memo is often organized in an IROC format. The A of IROC consists of breaking a rule down into its elements and concentrating on those elements in contention. Organizing an examination answer. Many essay examinations in school are organized around the major elements of the rules that should be analyzed. Charging the jury. When a judge charges, that is, instructs a jury, he or she will go over each of the elements of the causes of action and defenses in the case in order to tell the jury what standard to use to determine whether facts in support of those elements have been sufficiently proven during the trial. Introduction to Legal Analysis 309R Section D. The issue statement skill. After you have broken a rule into its elements, the next step is to identify the element in contention. That element then becomes the basis of a legal issue. An element is in contention when you can predict that the other side in the controversy will probably not agree on the definition of the element, whether the facts fit within the element, i.e., within its definition, or both. If a rule has 5 elements and you anticipate disagreement over all of them, phrase 5 separate issues. If, however, only one of the 5 elements will probably be in contention, phrase only one issue. There is no need to waste time over elements that will most likely not be the basis of disagreement. During informal discussions in a law office, you will often find that attorneys and paralegals phrase legal issues very broadly, almost in shorthand. For example, was Tom negligent? Does 12 apply? Can we use the trespass defense? While broad issue statements, such as these, can be good starting points for discussion, you need to be able to provide a more comprehensive statement of the issue. This is done by including, in your issue, a brief quote from the element in contention, and several of the important facts relevant to that contention. For example, suppose that you are analyzing the following rule and facts. 92. The operator of any vehicle riding on a sidewalk shall be fined $100. Facts. Fred rides his 10-speed bicycle on the sidewalk. He is charged with violating 92. The element breakdown and issue statement would be as follows. Elements of 92. 1. Operator. 2. Any vehicle. 3. Riding. 4. On a sidewalk. Issue. Is a 10-speed bicycle a vehicle under 92? The parties will probably agree that Fred rode his bicycle on a sidewalk, and that Fred was the operator of his bicycle. The first, third, and fourth elements therefore should not be made into legal issues. The only disagreement will be over the second element. Hence it is the basis of an issue. Note the quotation marks around the element in contention vehicle, and the inclusion of an important fact that is relevant to this contention. It was a 10-speed bicycle. Element in contention, that portion of a rule about which the parties cannot agree. The disagreement may be over the definition of the element, whether the facts fit within the element, or both. Legal issue. A question of law. A question of what the law is, or what the law means, or how the law applies to the facts. Assignment 7.2. Provide a comprehensive phrasing of the legal issue, or issues in each of the following situations. Of facts. Tom owns a 1999 Ford. One day, it stalls on a hill. The engine stops running. He wants to get the car off the street. He therefore pushes the car so that it glides off the street and onto the sidewalk. While pushing the car on the sidewalk, a police officer stops him. Statute 92. The operator of any vehicle riding on a sidewalk shall be fined $100. B. Facts. Harry Franklin works for the XYZ agency. In one of the agency's personnel files is a notation that Paul Drake, another agency employee, was once arrested for fraud. Harry obtains this information from this file and tells his wife, TIK skills OKA, /local about it. She also knows Paul. Harry is unaware that Paul has told at least 3 other employees about his fraud arrest. Regulation 20D. It shall be unlawful for any employee of the XYZ agency to divulge confidential material in any file of the agency. See facts. Jones has a swimming pool in his backyard. The pool is intended for use by the Jones family members and guests who are present when an adult is there to supervise. One hot summer night, a neighbor's child opens an unlocked door of a fence that surrounds the Joneses' yard and goes into the pool. There is no separate fence around the pool. The child knows that he should not be there without an adult. No one else is at the pool. The child drowns. Statute 77. Property owners are liable for the foreseeable harm that occurs on their property. D. Facts. Dr. Karya Jones is the family physician of the Richardson family. After an appointment with Mary Richardson, age 16, Dr. Jones prescribes birth control pills. Mary tells Dr. Jones that she can't afford the pills and does not want her parents to know she is taking them. Dr. Jones says she will give her a supply of the pills at no cost in exchange for an afternoon of office clerical work at Dr. Jones's office. Statute 25-403. A pharmacist must not sell prescription drugs to a minor. Left bracket section E. The definition's skill language can frequently be defined broadly or narrowly. Assume that Jim meets a friend in a parking lot and says to him, "You can use my car." Jim is quite upset, however, when the friend returns 5 months later after driving the car through about 20 states. The friend asserts that he did nothing more than use the car. The question then becomes, what definition of use was intended and communicated? Broad definition. Use means to operate or employ something for any purpose and for any length of. Narrow definition. Use means to operate or employ something for a reasonable purpose within a reasonable time. The same dynamic is found when interpreting ambiguous language within elements in contention. Recall the bicycle example discussed in the preceding section. 92. The operator of any vehicle riding on a sidewalk shall be fined $100. Facts. Fred rides his 10-speed bicycle on the sidewalk. He is charged with violating 92. Issue. Is a 10-speed bicycle a vehicle under 92? This controversy may well turn on whether vehicle should be defined broadly or narrowly. Fred will argue that it should be interpreted narrowly, whereas the government will argue for a broad definition. Broad definition. Vehicle means any method of transportation. Narrow definition. Vehicle means any motorized method of transportation. Whenever you have an element in contention that contains ambiguous language, you should put yourself in the shoes of each person in the controversy and try to identify what definition of the language each would propose. Think of a broad and a narrow definition and state which side would argue which definition. To help resolve a definition dispute, you would undertake some legal research. For example, you would try to find cases interpreting vehicle under 92 and trace the legislative history of 92. Often, however, you will not find the answer in the library. The precise question may never have arisen before. This is particularly true of recent statutes and regulations. Assignment 7.3. In each of the following problems, identify any ambiguous language in elements in contention. Give broad and narrow definitions of this language, and state which side would argue which definition. Do not do any legal research. A. Facts. Alice Anderson is 9 months pregnant. A police officer gives her a ticket for driving in a carpool lane, in violation of 101. The officer said he gave her the ticket because she was alone in the car at the time. Regulation 101. Carpool lanes can be used only by cars in which there is at least one passenger with the driver. B. Facts. Mary is arrested for violating 55. She is charged as a felon. She forced open the lock on the driver's side of a van at 5 p.m. Mary didn't know that the door on the passenger side was unlocked. She went into the back of the van and fell asleep on the floor. The police arrested her after waking her up at 9 p.m. The owner of the van claims that a $20 bill is missing. Mary had a $20 bill on her, but she said it was her own. Statute 55. A person who breaks and enters a dwelling at night for the purpose of stealing property therein shall be charged as a felon. Assignment 7.4. Analyze the problem in the following situations. Do not do any legal research. Simply use the facts and rules you are given. Be sure to include in your analysis what you have learned about elements, issues, and definitions. Use IROC for each issue. As a guide, use the John Smith drug/weapon example. On page 304, a Susan is arrested for carrying a dangerous weapon. While in a hardware store, she got into an argument with another customer. She picked up a hammer from the counter and told the other customer to get out of her way. The customer did so, and Susan put the hammer back. She was later arrested and charged with violating 402B, which provides, it is unlawful for anyone to carry a dangerous weapon. B. It is against the law in your state to practice law without a license. 39. Fred is charged with violating this law. He told a neighbor that a certain parking ticket received by the neighbor could be ignored because the police officer was incorrect in issuing the ticket. In gratitude, the neighbor buys Fred a drink. Assume that what Fred told the neighbor about the ticket was accurate and that Fred is not an attorney. C. Ted and Ann are married. Ted is a carpenter and Ann is a lawyer. They buy an old building that Ted will repair for Ann's use as a law office. Ted asks Ann to handle the legal aspects of the purchase of the building. She does so. Soon after the purchase, they decide to obtain a divorce. Ted asks Ann if she will draw up the divorce papers. She does so. Ted completes the repair work on the building, for which Ann pays him a set amount. Has Ann violated 75B that you found earlier in problem B of assignment 7.1 on page 308? Left bracket section F factor axolysis. Thus far we have concentrated on the analysis of elements in rules. Elements are preconditions to the applicability of the entire rule. If one element does not apply, the entire rule does not apply. We now turn to a closely related but different kind of analysis. JIC for analysis. A factor is simply one of the circumstances or considerations that will be weighed in making a decision, no one of which is usually conclusive. Factor 1 of the circumstances or considerations that will be weighed in making a decision, no one of which is usually conclusive. Elements and factors are no limited to the application of rules to facts. Many of the important decisions we make in everyday life involve the equivalent of elements and factors, e.g., picking someone to marry, buying a car or a house. When people look for a house, they consider space, neighborhood, area. Schools, affordability, etc. If an item is essential, it is an element. Suppose, for example, that you will not buy a house with less than 3 bedrooms. Then this is a precondition to the entire purchase, in the same manner as any single element of a rule is a precondition to the applicability of the entire rule. A house hunter may also want a large yard and a bus line within walking distance, but if these are not preconditions, they are simply factors to be considered, no one of which is necessarily dispositive or essential. If the bus line is a factor, the house hunter may decide to buy a particular house even though the bus line is not within walking distance. Why? Because this negative fact was examined in the light of everything else about the house, e.g. it had a very large yard, it was the right color, and on balance, the decision was to make the purchase. The bus line problem did not outweigh all of the other factors. Factors sometimes play an important role in legal analysis as well. Assume that 107 provides that a quotation from a copyrighted work is not an infringement or violation of the copyright if the quotation constitutes fair use. To determine whether fair use exists, 107 says that a court will consider the following factors. The purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. The nature of the copyrighted work. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And the effect of the use upon the potential market for or value of the copyrighted work. These four considerations are factors that the court will assess to decide whether someone has made fair use of a copyrighted work. Because they are factors, no one of them will be conclusive or determinative. Each one will be considered and balanced against the others. Assume that Mary O'Brien has a 3-page explanation of the energy crisis in the introduction to her 70-page copyrighted book that she sells. Ted Kelly decides to quote the entire explanation in a brochure that he compiles for a charity fundraising event for an environmental organization. He does not obtain the permission of O'Brien. Did Kelly infringe her copyright? We need to determine whether his quotation for the brochure constituted fair use. This requires a factor analysis because 107 tells us that fair use is determined by an assessment of factors. The first factor is the purpose and character of the use. Kelly was not trying to sell anything. He was engaged in a nonprofit activity raising funds for an environmental charity. The second factor is the nature of the copyrighted work. O'Brien's explanation of the energy crisis is in a book she sells. She is trying to earn a living from the book. The third factor is the amount used in the quote. Kelly used the entire explanation, consisting of 3 pages, from O'Brien's 70-page book. The fourth factor is the effect of the use on the potential market of the copyrighted work. Here we must investigate whether the use of the quotation in the brochure hurt the sale of O'Brien's book containing her explanation of the energy crisis. Some of the factors suggest that the use was fair, e.g. the brochure was not used for commercial purposes. Other factors suggest an unfair use, e.g. 3 pages from a short book is a fairly large percentage. No one factor is necessarily determinative. The court will balance all of these factors in order to determine whether Kelly made fair use of O'Brien's work. This is the nature of a factor analysis. While every rule has elements, not every rule has factors. To determine whether factors are present in a rule, look for the word character in the rule itself. Section 107 in our example used this word. If the word CFOR is not in the rule, look for words such as consider, assess, or evaluate preceded or followed by a list. For example, 20. To determine whether the penalty will be waived, the agency shall consider the amount of the harm, the timing of the violation, and the extent to which the act was performed intentionally or accidentally. The word consider in 20, followed by a list, suggests that a factor analysis is required. Be careful, however. There are no magic words that will always signal the need for a factor analysis. You must examine the rule carefully in order to determine whether you are being told that several items mentioned in the rule must be weighed in order to decide whether the rule applies. Once you find factors in a rule, you simply examine the factors one at a time by connecting the facts you have or must investigate to each factor. Further investigation is of 10 called for because of the large number of facts that are usually needed to assess each of the factors mentioned in the rule. One of the benefits of this kind of analysis is that it will help the office identify these investigation needs. What is the relationship between elements and factors? As indicated, all rules have elements. Sometimes the applicability of an element is determined by the definition of that element. See the definition skill in the preceding section. At other times, however, the applicability of an element is determined by factors. Fair use is one of the elements of 107. But there is no traditional definition available for this element. Its applicability is determined by a factor analysis. Assignment 7.5 Rachel Sanderson is running for mayor. In a campaign speech, she tells her audience that the city must not neglect the poor. She gives one examples of the kinds of poor families she means, each of which has experienced a different kind of poverty, e.g., poverty resulting from divorce, poverty resulting from illness. Harry Smith finds out that Sanderson's speech took numerous quotes from a short story he wrote for a college magazine some years ago. Smith is a mail carrier in the city where Sanderson is running for mayor. His story was entitled The Faces of the Downtrodden. It contained 15 categories of families in distress. Sanderson used 10 of them in her speech. She used his labels for the 1 categories. He devoted 2 paragraphs to each category in his story. Sanderson's speech used at least 1 full paragraph, word for word, for each category from Smith's story. Was Sanderson's speech a fair use of Smith's story? Do a factor analysis on the applicability of 17. In your analysis, you will need to identify further facts that should be investigated. State how such facts might be relevant to your factor analysis. B. Section 100 provides as follows. Motorists shall be liable for the foreseeable harm or damage caused by their driving. To determine foreseeability, the court must consider road conditions, speed, weather, visibility, and any other circumstance that would affect the likelihood of the harm or damage occurring. Charles Wilson ran his truck into the side of a parked car when he came to an abrupt stop at an intersection. There was some oil on the road. Wilson's car skidded on the oil at the time of his attempt to stop. The incident occurred at 7 p.m., just after rush hour. Was the damage caused by Wilson foreseeable? Do a factor analysis on the applicability of 100. In your analysis, identify further facts that you would need to investigate. State how such facts might be relevant to your factor analysis. Section G. Brief a summary of the briefing court opinions, main or essential parts of a court opinion. Prior also the word brief has several meanings, sometimes refers to a trial. First, to brief a court opinion, is to summarize its major components, e.g. key facts, briefer to an appellate issues, reasoning disposition. Such a brief is your own summary of the opinion for later brief. Trial brief: an attorney's set of notes on the strategy he or she proposes to follow in conducting a trial. Appellate brief: a document submitted by a party to an appellate court and served on the opposing party, in which arguments are presented on why the rulings of a lower court should be approved, modified, or reversed. Unethical reporter: a collection of cases printed by a private or commercial printer/publisher without specific authority from the government. Citation: a reference to any material printed on paper or stored in a computer database. A paper or online address where you can go to read something. Appellant: the party bringing an appeal because of dissatisfaction with something the lower tribunal did. Sometimes called the petitioner. Use: this section of the chapter covers the skill of briefing opinions. The next section covers the more important skill of applying opinions. As you will see, you cannot apply an opinion unless you know how to brief it. Second, the word brief refers to a trial brief, which is an attorney's set of notes on how he or she will conduct the trial. The notes often placed in a trial notebook will be on the opening statement, witnesses' exhibits, direct and cross-examination, closing argument, etc. This trial brief is sometimes called a trial manual or trial book. Trial brief has other meanings as well. In some states, for example, when an attorney submits a written argument in support of a motion during a trial, the writing is called a trial brief. Third, the appellate brief is the formal written argument to a court of appeals on why a lower court's decision should be approved, modified, or reversed. The focus of the appellate brief is on the claimed errors made below. An appellate brief is submitted to the appellate court and served on the other side. Here our concern is the first meaning of the word brief, a summarization of the essential components of a court opinion. See Exhibit 7.2 later in the chapter. Before we examine these components, we will study an opinion as it might appear in a library reporter volume. The circled numbers in the Bruni opinion below are explained after the opinion. The California Reporter is an unofficial reporter of state opinions in California. The 100 indicates the volume number of the reporter. An unofficial reporter is a collection of cases printed by a private or commercial printer/publisher without specific authority from the government. Many of the terms covered in this overview will be examined again in greater detail in Chapter 11. 2. The Brum opinion begins on page 600. The citation of this opinion is People v. Bruni, 25 Cal App. 3D196 100 Cal RPTR 6001972. The official site is given at the top of the first column, above the word people. D. When the people, or the state brings an action, it is often a criminal law opinion. This is an appellate court decision. Trial court decisions are appealed to the appellate court. The appellant is the party, bringing the appeal because of dissatisfaction with the ruling, or decision of the lower court. The state of California brought the case as the plaintiff and prosecutor in the lower court Superior Court, County of San Mateo, and is now the appellant in the higher court Court of Appeal, 1st District, Division 1. /100 California Reporter E-25 Cal, App 3D 196 The people of the SUI of California plaintiff and appellant, J, V_wide and judgment, reversed and I deny motion, to suppress the EI court evidence. Ronald James Bruni. Defendant and Respondent. Court of Appeal. 1st District, April 27, 1972 Ring, denied May 22, 1972, the Superior Court. County of San Mateo. W. Howard Hartley. J. Dismissed information, after obtained pursuant to CCH warrant, specifying daytime, service but served D, at 9:30 p.m. And the people appealed the County of Appeal, held that the search warrant, specifying day, but served at 9:30 p.m. was valid within hours, specified under amended time of service, if search warrant providing instead of daytime, that normal service, was proper between the hours of 7 o'clock a.m. and 10 o'clock p.m. 1. Searches and seizures 3.81, in light of amendment of provision, as to time of service of search warrant, providing instead of daytime, that normal service, was proper between the hours of 7 o'clock a.m. and 8 o'clock p.m. Daytime, in provision for Form 4 warrant, was implicitly amended to provide same period, force as that under the other amended provision. S. and Penn Code, 4715291533. West Side Code Civ Proc, 1859-2. Searches and seizures equal 3.81, service under search warrant, specifying daytime, service but served at 9:30 p.m. was valid since it was within hours, specified under amended provision, for time of service of search warrant, providing instead of daytime, that normal service, was proper between the hours of 7 o'clock a.m. and 10 o'clock p.m. West and Penn Code. Evelt J. Younger. Any General of California Edward P. Eberlin. Robert R. Cranucci. Deputy Attorney General. San Francisco, for appellant. William F. Delucal. Regalado & Lingual. Redwood City, for respondent. Greater than Smith, Judge. The people appeal from to judging and information after suppressure, where the evidence was obtained. Search warrant specifying daytime, which was served at 9:30 p.m. At Nilani dismiss of evidence, y. Pursuant to in 1970, Section 1533 of the Penal Code was amended to eliminate the provision for daytime v service for normal service of a search warrant. In stead of daytime. The statute now specifies, nor 151 mil service, as proper between the hours of 7 o'clock m and 10 o'clock p.m. Apparently by oversight, the legislature neglected to also amend the mandatory provisions under Section 1529 of the Penal Code, which continues to require day mandatory requirements of search warrants unless Section 1529 of the Penal Code is read as having been amended by implication, when Section 1533 of the Penal Code was expressly amended. Otherwise, the only warrant an issuing magistrate could authorize, without possibly violating one or the other statute, would be one for unlimited service, at any hour off or night, upon wing of good, the provisions of the Penal Code, construed according to the fair import of the RMS, with a view to effect its objects. Justice. Penn, Code 4, in the greater than n of a statute, the intention of the legislature is to be pursued, if possible. And W narrow and particular provision, R latter, is paramount to the former, code /7c/isa.ena JLS, 1859. P right bracket, under the definition in Section 7 of the Penal Code, daytime is defined as the period, hours, of 7 o'clock m and 1 o'clock p.m. Istab vj caret x asterisk caret asterisk asterisk caret caret asterisk caret. The amendment of section 1533 of the Penal Code. Under the general rules of statutory law or provisions of section 1529 of the Penal Code, as having been impleedly amended to provide the f/same period for service as that under amended sec. v.Illion 1533 of the Penal Code, 18, where the language of a statute is reasonably susceptible of two constructions, one of which in application will render it reasonable, fair and harmonious with its manifest purpose, and another which would be productive of absurd consequences. The former construction will be adopted. Citation. And if certain provisions are repugnant, effect should be given to those which best comport with the end to be accomplished, and render the /X statute effective, rather than negatory. Dept. of J2 Motor Vehicles, of California v. Indus, ASCOM 1939, MK.2D189, 195, 93 P2D131, 134. Q2 right bracket. We hold that the people allowed in the hours specified under amended section 15s3 of the Penal Code. See Tidwell v. Supiner Court 1971, 17 Cal.Up.3D 780 786 to 787, 95 Cal.RPTR 213 VV. This court has always been scrupulous in demanding a high standard for the admission of evidence pursuant to warrants. Our ruling today does not violate this standard. The integrity of our trial system, in large measure, depends upon the integrity of the evidence admitted at trial. The case before us deals with the timing of serving a warrant, underscore. If th less than case had involved other aspects of the war *2l rant such as its specificity, our result would probably have been different. The judgment is reversed, and the trial court is directed to deny the motion to suppress /YJO evidence. V_/Jones. Judge Co *M. Atcher intended to amend section 1529 of the Penal Code. It should have done so expressly. It is not the function of the judiciary to amend the statutes passed by the legislature. The public has a right to rely on the written language of statutes. In fact, we frequently admonish the citizenry, if they ignore that language for the courts, to alter the language after the fact. Not only infringes upon the right of the legislature to be the sole entity under our system that can enact and amend legislation, but also is a signal to the public and to government officials that they can no longer trust the law as validly passed by the legislative branch. Both results are intolerable. One would affirm the judgment below zero. Bruni was the defendant in the lower court because he was being sued, or in this case, charged with a crime. The appeal is taken against him by the people appellant because the lower court ruling was favorable to Bruni, to the dissatisfaction of the people. The party against whom a case is brought on appeal is called the respondent. Another word for respondent is appellee. DCR 10096 refers to the docket or calendar number of the case. CR stands for criminal. Docket numbers are not used in the citation of reported opinions. Reported here means printed in a traditional reporter. See number 7 below. 6. Make careful note of the name of the court writing the opinion. As soon as possible, you must learn the hierarchy of state courts in your state. See Exhibit 6.2 in Chapter 6. In many states, there are 3 levels of courts: trial level, middle appeals level, and supreme level. Most opinions are appealed from the trial court to the middle appeals level, and then to the supreme level. Here we know from the title of the Court of Appeal that it is an appellate court. It is not the Supreme Court, because in California the highest court is the California Supreme Court. The name of the court is significant because of legal authority. If the court is the highest or Supreme Court of the state, then the opinion would be applicable throughout the state. A middle appeals court opinion, however, appears only in the area of the state over which it has jurisdiction. When you see that the opinion was written by a trial or middle appeals court, you are immediately put on notice that you must check to determine respondent, the party against whom an appeal is brought. Also called the appellee, reported printed in a traditional reporter. Syllabus A1 paragraph summary of an entire court opinion, usually written by a private publisher, rather than by the court. Headnote A. Small paragraph summary of a portion of a court opinion, written by a private publisher. Key number A. General topic e.g. searches and seizures, and a number for one of its subtopics e.g. 3.81. Key numbers are used by West Group to organize millions of cases by topic in its digests. Digest volumes that contain summaries of court opinions. See glossary for other meanings of digest. Whether the opinion was ever appealed subsequent to the date of the case. As we will learn in Chapter 1.1, the two main systems for checking the subsequent history of an opinion are Shepard's citations and key cite. See Exhibit 1.30 in Chapter 11. At when a reported opinion is being cited, only the year here 1972 is used, not the month or day April 27th. If the opinion has not yet been reported, the month, day, and year are used, along with the docket number. Sometimes the text of the reported opinion will also give you the date of the hearing, or rehearing, as well as the date of the decision. The year of the decision is still the critical one for citation purposes. Here the editors provide the reader with a summary of what the opinion says. The court did not write this summary. The editors did. It therefore is not an official statement of the law. It is merely an aid to the reader, who can quickly read this summary to determine whether the opinion covers relevant areas of law. This summary paragraph is often called the syllabus. Here continues the unofficial summary, providing the reader with what procedurally must happen as a result of the April 27th opinion. To these are editors' headnotes, which are small paragraph summaries of portions of the opinion. When the editors first read the opinion, they decide how many major topics or issues are covered in the opinion. Each of these topics is summarized in a headnote, all of which are then given consecutive numbers, here 1 and 2. These numbers correspond with the bracketed numbers, left bracket 1 right bracket and left bracket 2 right bracket, in the opinion itself. See low caret. If, for example, you wanted to read the portion of the opinion that was summarized in the second headnote of the opinion, you would go to the text of the opinion that begins with the bracketed left bracket 2 right bracket. The headnotes also have a key number, which consists of a topic and a number, here searches and seizures caret 3.81. Each headnote will also be printed in the digests of West Group. Digests are volumes that contain nothing but the headnotes of court opinions. You can find out what other courts have said about the same or similar points by going to the digest volumes, looking up the key number of a headnote, e.g. searches and seizures caret 3.81, and reading summary paragraphs from many court opinions, such as our opinion, People v. Brum. Caution is needed in reading the syllabus and headnotes of opinions. As indicated earlier, they are not written by the court, and therefore should never be relied on or quoted. They are merely preliminary guides to what is in an opinion. To understand the opinion, you must carefully study the language of the opinion itself, through the process called briefing, and here are the attorneys who represented the appellant and respondent on appeal. Note that the Attorney General's office represented the people. The Attorney General, or the District Attorney's office, represents the state in criminal cases. 12. The opinion begins with the name of the judge who wrote the opinion. Judge Smith. In this spot you will sometimes find the words per curiam opinion or memorandum opinion. A per curiam opinion is a court opinion that does not mention the individual judge who wrote the opinion. Such opinions are usually short because they cover relatively simple issues. A memorandum opinion (mem) also often does not name the judge who wrote the opinion. It will often briefly state the conclusion holding of the opinion or the disposition, without providing reasons. 13. In reading or briefing an opinion, make note of the history / of the litigation to date. The lower court rendered a judgment dismissing the information similar to an indictment against Bruni after certain evidence was suppressed and declared inadmissible. This is the prior proceeding. The people have now appealed the judgment. This is the present proceeding. If the words information and suppression are new to you, look them up in a legal dictionary. Do this for every new word. In this book, also check the definitions of such words in the glossary. It is critical to state the facts of the opinion accurately. Here the facts are relatively simple. A search warrant that said daytime service was served at 9:30 p.m., and evidence was taken pursuant to this search warrant. Defendant objected to the admission of this evidence at trial. In most opinions, the facts are not this simple. The facts may be given at the beginning of the opinion, or they may be scattered throughout the opinion. If you confront the latter situation, you must carefully read the entire opinion to piece the facts together. Ultimately, your goal is to identify the key facts of the opinion. A key fact is simply one that was essential or very important to the result or holding of the court. The next critical stage of reading an opinion is to state the issue or issues that the court was deciding. When phrasing an issue, you should make specific reference to the language of the rule in controversy, e.g. a statute, along with important facts that raise this controversy. The issue in Brum is as follows. When 1533 was amended to allow service up to 10:00 p.m., did the legislature implicitly also amend 1529, which continues to require daytime service, so that evidence obtained pursuant to a warrant served at 9:30 p.m. can be admitted into evidence? See the discussion earlier in the chapter section D on phrasing issues, particularly phrasing them comprehensively at the court refers to other statutes to support the conclusion it will reach. Note the interrelationship of the statutory sections. One statute is interpreted by interpreting other statutes. Section 4 of the Penal Code Pen Code says that the sections of the Penal Code are to be interpreted construed rationally in order to carry out their purpose or objective and to promote justice. Section 1859 of the Code of Civil Procedure Code Civ Proc says that, when a general and a particular section are inconsistent, the latter is preferred. The interrelationship of the statutes, in this opinion, is as follows. Section 1529 of the Penal Code still says daytime. Section 7 of the Penal Code defines daytime as sunrise to sunset. Section 1533 of the Penal Code, as amended, says between 7:00 a.m. and 10:00 p.m. Section 4 of the Penal Code and 1859 of the Code of Civil Procedure provide principles of interpreting statutes that are inconsistent. In the same manner, a court will refer to other opinions to support its ruling. In this way, the court argues that the other opinions are precedents for the issues before the court. The court in People p. Bruni is saying that Dept of Motor Vehicles of California v. Indus, Ace and Tidwell v. Superior Court are precedents for its own ruling. Precedent is important because of the principle of stare decisis, which means that courts should decide similar issues in the same way, unless there is good reason to do otherwise. Here is the reasoning of the court to support its ruling. If there is a general statute such as 1529 and a specific statute such as 1533 that are inconsistent, the latter is paramount and is preferred. Hence the legislature probably intended to amend the more general Statute 1529 when it amended 1533-19. The result, or holding, of the court's deliberation of the issue must then be identified. The holding is that 1529 was implicitly amended to authorize service up to 10:00 p.m. The holding is also called the court's ruling. 20. The consequences of the court's resolution of the issue are then usually stated, as here, toward the very end of the opinion. The judgment of the lower court is reversed. The lower court cannot continue to suppress, i.e. declare inadmissible, the evidence seized at the 9:30 p.m. search. This is the disposition of the court. An appeals court could take a number of positions with respect to a lower court's decision. It could affirm it, modify it, reverse it only in part, or remand the case, send it back to the lower court with instructions on how to proceed, such as how to retry the case. In theory, a judge must be very precise in defining the issue before the court and in resolving only that issue. The judge should not say more than must be said to decide the case. This theory, however, is sometimes not observed. This can make your job more difficult. You must wade through the language of the court to identify 1. The key facts, 2. The precise issues, 3. The precise holding, and 4. The precise reasoning. The worst tangent that a judge can stray into is called dictum. Dictum is a judge's or court's view of what the law is or might be on facts that are not before the court. Judge Smith indicated that the result of the case might be different if the warrant were not specific, e.g., if it did not name the individual to be searched or what the investigator was looking for. This was not the situation in Brum. Therefore, Judge Smith's commentary or speculation is dictum qui facte, critical fact, a fact that is essential or very important to the conclusion or holding of a court. Precedent, a prior decision or opinion that can be used as a standard or guide in a later similar case. Stare decisis, courts should decide similar issues in the same way unless there is a good reason for the court to do otherwise. In resolving an issue before it, the court should be reluctant to reject precedent, a prior opinion covering a similar issue, reasoning, an explanation of why the court resolved a legal issue the way it did, why it reached the particular holding for that issue. Holding, a court's answer to a specific question or issue that arises out of the facts before the court. Also called a ruling disposition, the order of a court reached as a result of its holding. Remand, to send a case back to a lower tribunal with instructions from the appellate court on how to proceed. Dictum, a statement made by a court that was not necessary to resolve the legal issues growing out of the specific facts before the court. A court's comments on the law that applies or that might apply to facts that are not before the court. Majority opinion, the opinion whose result and reasoning are supported by at least half plus one of the judges on the court. Concurring opinion, the opinion written by less than a majority of the judges on the court that agrees with result reached by the majority, but not with all of its reasoning. Dissenting opinion, an opinion of one or more judges that disagrees with the result and the reasoning of the majority. 22. On any court, there may be several judges. They do not always agree on what's liable be done. The majority controls. In less than Judge Smith wrote the majority opinion. A concurring opinion is one that votes for the result reached by the majority, but for different reasons. In Judge Jones concurred but specified that he accepted only the result of Judge Smith's opinion. Normally, judges in such situations will write an opinion indicating their own point of view. Judge Jones did not choose to write an opinion. He simply let it be known that he did not necessarily agree with everything Judge Smith said. All he agreed with was the conclusion that the warrant was validly served. To reach this result, Judge Jones might have used different reasoning, relied on different opinions as precedent, etc. If all the judges on the bench agree on the result and reasoning, the opinion is called a unanimous opinion. 23. A dissenting opinion disagrees with part or with all of the opinion of the majority. Dissenting opinions are sometimes heated. Of course, the dissenter's opinion is not controlling. It is often valuable to read, however, in order to determine what the dissenter thinks that the majority decided. We turn now to the 10 components found in a comprehensive brief of a court opinion, Exhibit 7.2, followed by a 10-part NEF of BMNI that conforms to the guidelines of brief. Presented in Exhibit 7.2. You should keep in mind, however, that not everyone follows the same briefing format or uses the same labels for the different components of a brief. Exhibit 7.2, Comprehensive Brief of a Court Opinion II. Citation. Where can the opinion be found? Provide a full citation to the opinion you are briefing, e.g., the volume number of the reporter, the abbreviation of the name of the reporter, the page on which the opinion begins, the date of decision. Parties. Who are the parties? Identify the lead parties, their relationship to each other, their litigation status, when the case began, e.g., defendant, and their litigation status, now, e.g., appellant. Objectives of parties. When the litigation began, what were the parties seeking? State the ultimate objectives of the parties, in terms of the end result they want from the litigation. At this point, do not focus on tactical or procedural objectives. IV theories of the litigation. What legal theories are the parties using? At the trial level of a civil case, name the cause of action, e.g., negligence, breach of contract, violation of 65, and the main defenses. In a criminal case, state what the prosecution was for, and the response of the defendant. If the opinion is now on appeal, briefly state the main theory of each party. Where relevant, always refer to specific rules. History of the litigation. What happened below? What are the prior proceedings? For each prior proceeding, briefly state the nature of the proceeding, the party initiating it, the name of the court or agency involved, and the result of the proceeding. For the present proceeding, briefly state the nature of the proceeding, who initiated it, and the name of the court or agency involved. Facts. What are the facts? Specifically state the facts that were very important or key to the holding reached by this court. This is one of the most significant parts of the brief. For each holding, identify the facts that were most important to the court. Note the facts that the court emphasized by repetition, or by the use of adjectives, such as material, crucial or critical. You know you have identified a key fact if you can say that the holding would probably have been different if that fact had not been in the opinion. Issue S. What are the questions of law now before the court? Provide a comprehensive statement of each issue by making specific reference to the language of the rule in controversy, e.g. a statute, along with important facts that raise this controversy. VIII. Holding S. What are this court's answers to the issues? If you have stated each issue comprehensively, it's holding a simple yes or no response. IX. Reasoning. Why did the court answer the issues the way it did? State the reasons for each holding. X. Disposition. What order did this court enter as a result of its holding S? State the consequences of the court's resolution of the issue S. VVIVIIB. Comprehensive brief of People v. Bruni. Citation. People p. Bruni, 25 Cal App, 3D196, 100 Cal RPTR, 600 parties, 1972. People of California / prosecution / plaintiff below / appellant here. Objectives of parties. Theories of the litigation. History of the litigation. Prior proceeding. Present proceeding. Facts. Issue. Holding. Reasoning. Disposition. Bruni / accused / defendant below / respondent here. The people want to convict and punish Bruni for criminal conduct. Bruni wants to avoid conviction and punishment. 1. Trial. The people sought to prosecute Bruni for the alleged commission of a crime. The opinion does not tell us which crime. The legal theory that justifies the bringing of the prosecution is the alleged commission of a crime. Because Bruni is resisting the prosecution, we can assume that the basis and theory of his case is simply that he did not commit the crime. At the trial, this was probably his main defense to appeal. Bruni says that the state violated 1529 when the search warrant was served at 9:30 p.m. The people say 1529 was implicitly amended by 1533, which allows service up to 10:00 p.m. 1. Trial. A criminal prosecution was brought by the people, the state, in the Superior Court San Mateo. Result. Judgment for Bruni dismissing the information after the court granted a motion to suppress the evidence obtained from the search warrant. To appeal. The people now appeal the dismissal of the information to the Court of Appeals First District. A search warrant that said daytime service was served at 9:30 p.m. Evidence was obtained during this search, which the people unsuccessfully attempted to introduce during the trial. When 1533 was amended to allow service up to 10:00 p.m., did the legislature implicitly also amend 1529, which continues to require daytime service, so that evidence obtained pursuant to a warrant served at 9:30 p.m. can be admitted into evidence? Yes, if there is a general statute such as 1529 and a specific statute such as 1533 that are inconsistent, the specific statute is paramount and is preferred. Hence the legislature probably intended to amend the more general statute 1529 when it amended 1533. The trial court's judgment dismissing the information is reversed. When the trial resumes, the court must deny the motion to suppress the evidence based on the time of the service. At the end of your brief, you should consider adding some notes that cover the following topics. What has happened to the opinion since it was decided? Has it been overruled? Has it been expanded or restricted by later opinions? You can find the history of an opinion and its treatment by other courts by shepherdizing or key citing the opinion. See Exhibit 1.30 in Chapter 1.1. Summary of concurring opinions, if any. Summary of dissenting opinions, if any. Interesting dicta in the majority opinion, if any. Your own feelings about the opinion. Was it correctly decided? Why or why not? A thumbnail brief is, in effect, a brief of a brief. It is a shorthand version of the 10-part comprehensive brief. A thumbnail brief includes abbreviated versions of 6 of the components: citation, facts, issues, holdings, reasoning, disposition, and leaves out 4 of the components: parties, objectives, theories, history of the litigation. By definition, you must know how to do a comprehensive brief before you can do a shorthand one. Many students fall into the trap of doing only shorthand briefs. It takes considerable time to do a comprehensive brief. It is highly recommended, however, that early in your career, you develop the habit and skill of preparing briefs comprehensively. Without this foundation, your shorthand briefs will be visibly superficial. Shorthand briefs are valuable time savers when communicating with colleagues, but they are not substitutes for comprehensive briefs. Thumbnail brief of People v. Bruni. People v. Brum, 25 Cal App, 3D196, 100 Cal RPTR, 6001972, a daytime search warrant served at 9:30 p.m. uncovers evidence that the people unsuccessfully attempt to introduce during the trial. Did 1533, which allows service up to 10:00 p.m. Impletely amend 1529, which requires daytime service so that evidence obtained from a 9:30 p.m. search warrant is admissible. Yes, a specific statute, 1533, is preferred over an inconsistent general one, 1529. Dismissal of the information is reversed. Motion to suppress the 9:00 p.m. obtained evidence must be denied. Citation, facts, issue, holding, reasoning, disposition. Assignment 7.6. Prepare a comprehensive and a thumbnail brief of each of the following 3 opinions. United States v. Koval printed below. B. Quinn v. Lum printed below. You do not need to give the citation of this opinion. It is an actual opinion, but was not reported in a traditional reporter. C. Brown v. Hammond, on page 228 in Chapter 5. United States v. Koval. United States Court of Appeals, 2nd Circuit, 296 F2D 9181961, Friendly Circ Judge. This appeal from a sentence for criminal contempt for refusing to answer a question asked in the course of an inquiry by a grand jury raises an important issue as to the application of the attorney-client privilege to a non-lawyer employed by a law firm. Koval is a former Internal Revenue agent having accounting skills. Since 1943, he has been employed by Kamerman & Kamerman, a law firm specializing in tax law. A grand jury in the Southern District of New York was investigating alleged federal income tax violations by Hobbs, a client of the law firm. Koval was subpoenaed to appear on September 6, 1961. The law firm advised the Assistant United States Attorney that since Koval was an employee under the direct supervision of the partners, Koval could not disclose any communications by the client or the result of any work done for the client unless the latter consented. The assistant answered that the attorney-client privilege did not apply to one who was not an attorney. On September 7, the grand jury appeared before Judge Cashin. The Assistant United States Attorney informed the judge that Koval had refused to answer several questions on the grounds of attorney-client privilege. He proffered respectable authority that an accountant, even if he is retained or employed by a firm of attorneys, cannot take the privilege. The judge answered, "You don't have to give me any authority on that." A court reporter testified that Koval, after an initial claim of privilege, had admitted receiving a statement of Hobbs' assets and liabilities, but that when asked what was the purpose of your receiving that, had declined to answer on the ground of privilege because the communication was received with a purpose, as stated by the client. Later questions and answers indicated the communication was a letter addressed to Koval. After verifying that Koval was not a lawyer, the judge directed him to answer, saying, "You have no privilege as such." The reporter then read another question Koval had refused to answer. "Did you ever discuss with Mr. Hobbs or give Mr. Hobbs any information with regard to treatment for capital gains purposes of the Atlantic Beverage Corporation sale by him?" The judge again directed Koval to answer reaffirming, "There is no privilege. You are entitled to no privilege, as I understand the law." Later on September 7, they and Koval's employer Jerome Kamerman, now acting as his counsel, appeared again before a Judge Cashin. The assistant told the judge that Koval had refused to answer some of the questions, which you had directed him to answer. A reporter reread so much of the transcript heretofore summarized as contained the first two refusals. The judge offered Koval another opportunity to answer, reiterating the view, there is no privilege to this man at all. Counsel referred to New York Civil Practice Act 353, which we quote in the margin. Counsel reiterated that an employee who sits with the client of the law firm occupies the same status as a clerk or stenographer or any other lawyer. The judge was equally clear that the privilege was never extended beyond the attorney. The court held Koval in contempt, sentenced him to an attorney or counselor at law shall not disclose, or be allowed to disclose, a communication made by his client to him, or his advice given therein, in the course of his professional employment, nor shall any clerk, stenographer or other person, employed by such attorney, or counselor, disclose, or be allowed to disclose any such communication, or advice. Years imprisonment, ordered immediate commitment and denied bail. Later in the day, the grand jury having indicted, Koval was released until September 12, at which time, without opposition from the government, I granted bail pending determination of this appeal. Here the parties continue to take generally the same positions as below. Koval, that his status as an employee of a law firm automatically made all communications to him from clients privileged. The government, that under no circumstances could there be privilege with respect to communications to an AC accountant. The New York County Lawyers Association, as amicus curiae, has filed a brief generally supporting Koval's right position. Decision: under what circumstances, if any, the attorney-client privilege may include a communication to a non-lawyer by the lawyer's client, is the result of two conflicting forces. One is the general teaching that the investigation of truth and the enforcement of testimonial duty demand the restriction, not the expansion, of these privileges. 8 Wigmore, Evidence McNaughton Rev. 1961, 2192, p. 73. The other is the more particular lesson that as, by reason of the complexity and difficulty of our law, litigation can only be properly conducted by professional men, it is absolutely necessary that a man should have recourse to the assistance of professional lawyers, and it is equally necessary that he should be able to place unrestricted and unbounded confidence in the professional agent, and that the communications he so makes to him should be kept secret. Jessel M. R. and Anderson v. Bank, 2ch.d644-649-1876. Nothing in the policy of the privilege suggests that attorneys, simply by placing AC accountants, scientists or investigators on their payrolls, and maintaining them in their offices, should be able to invest all communications by clients to such persons, with a privilege the law has not seen fit to extend when the latter are operating under their own steam. On the other hand, in contrast to the Tudor times, when the privilege was first recognized, the complexities of modern existence prevent attorneys from effectively handling clients' affairs without the help of others. Few lawyers could now practice without the assistance of secretaries, file clerks, telephone operators, messengers, clerks not yet admitted to the bar, and aides of other sorts. The assistance of these agents being indispensable to his work, and the communications of the client being often necessarily committed to them by the attorney, or by the client himself, the privilege must include all the persons who act as the attorney's agents. 8 Wigmore Evidence, 2301 and at 53 ALR 369-1928. United States v. Koval, United States Court of Appeals, 2nd Circuit, 296 F2D, 918-1961. Continued. Indeed, the government does not here dispute that the privilege covers communications to non-lawyer employees, with a menial or ministerial responsibility that involves relating communications to an attorney. We cannot regard the privilege as confined to menial or ministerial employees. Thus we can see no significant difference between a case where the attorney sends a client speaking a foreign language to an interpreter to make a literal translation of the client's story, a second where the attorney, himself having some little knowledge of the foreign Tongue has a more knowledgeable non-lawyer employee in the room to help out. A third where someone, to perform that same function, has been brought along by the client, and a fourth where the attorney, ignorant of the foreign language, sends the client to a non-lawyer proficient in it, with instructions to interview the client on the attorney's behalf, and then render its own summary of the situation, perhaps drawing on his own knowledge in the process, so that the attorney can give the client proper legal advice. All four cases meet every element of Wigmore's famous formulation, 2292. 1. Where legal advice of any kind is sought to, from a professional legal advisor, in his capacity as such. 3. The communications relating to that purpose. 4. Made in confidence. 5. By the client. 6. Are at his instance permanently protected. 7. From disclosure by himself, or by the legal advisor. 8. Except the protection be waived. Section 2301 of Wigmore would clearly recognize the privilege in the first case, and the government goes along to that extent. 2301 would also recognize the privilege in the second case, and 2301 in the third, unless the circumstances negated confidentiality. We find no valid policy reason for a different result in the fourth case, and we do not read Wigmore as thinking there is. Laymen consulting lawyers should not be expected to anticipate niceties, perceptible only to judges and not even to all of them. This analogy of the client speaking a foreign language is by no means irrelevant to the appeal at hand. Accounting concepts are a foreign language to some lawyers in almost all cases, and to almost all lawyers in some cases. Hence the presence of an accountant, whether hired by the lawyer or by the client, while the client is relating a complicated tax story to the lawyer, ought not destroy the privilege, any more than would that of the linguist in the second or third variations of the foreign language theme discussed above. The presence of the accountant is necessary, or at least highly useful, for the effective consultation between the client and the lawyer, which the privilege is designed to permit. By the same token, if the lawyer has directed the client, either in the specific case or generally, to tell his story in the first instance, to an accountant engaged by the lawyer, who is then to interpret it so that the lawyer may better give legal advice, communications by the client reasonably related to that purpose ought fall within the privilege. There can be no more virtue in requiring the lawyer to sit by while the client pursues these possibly tedious preliminary conversations with the accountant than in insisting on the lawyer's physical presence while the client dictates a statement to the lawyer's secretary or is interviewed by a clerk not yet admitted to practice. What is vital to the privilege is that the communication be made in confidence for the purpose of obtaining legal advice from the lawyer. If what is sought is not legal advice but only accounting service, or if the advice sought is the accountant's rather than the lawyer's, no privilege exists. We recognize this draws what may seem to some a rather arbitrary line between a case where the client communicates first to his own accountant no privilege as to such communications, even though he later consults his lawyers on the same matter. Gripev. United States 189 F.2D 459, 463 sixths for 1951, and others, where the client in the first instance consults a lawyer who retains an accountant as a listening post, or consults the lawyer with his own accountant present. But that is the inevitable consequence of having to reconcile the absence of a privilege for AC accountants, and the effective operation of the privilege of client and lawyer under conditions where the lawyer needs outside help. We realize also that the line we have drawn will not be so easy to apply, as the simpler positions urged on us by the parties. The district judges will scarcely be able to leave the decision of such cases to computers. But the distinction has to be made if the privilege is neither to be unduly expanded nor to become a trap. The judgment is vacated, and the cause remanded for further proceedings. Consistent with this opinion, I do not deal in this opinion with the question under what circumstances, if any, such communications could be deemed privileged on the basis that they were being made to the accountant as the client's agent, for the purpose of subsequent communication by the accountant to the lawyer. Communications by the client's agent to the attorney are privileged. 8 Wigmore Evidence, 2317-1. Quitin v. Lum, and Cronin Fried, Sekiu e Karat Kekina Civ No. 80, 1284 Hawaii Court of Appeals, on January 25, 1984, Richard K. Quinn, attorney at law, a law corporation, filed suit against Roger Lean Lum, a member of the Hawaii Association of Legal Assistants HALA, and formerly legal secretary, with the Quinn firm, for injunctive relief based on the allegation that Mrs. Lum possesses confidential client information from her work as Quinn's legal secretary, which information would be transmitted to the co-defendant Mrs. Lum's new employer, Cronin Fried, Sekiu & Kekina, attorneys at law, if she were to begin her employment with the Cronin firm as a legal assistant. On or about January 3, 1984, Mrs. Lum notified Quinn that she had accepted a position as a paralegal with the Cronin firm. Quinn subsequently discussed and corresponded with Mr. Cronin regarding the hiring of Mrs. Lum, who was scheduled to begin work with the Cronin firm on January 30, 1984. Mr. Cronin repeatedly refused Quinn's request that she not be hired by the Cronin firm. On January 26, a hearing on the application for a temporary restraining order was heard by Judge Philip T. Chun, of the Circuit Court of the First Circuit, State of Hawaii. The application was denied. Quinn alleges in the pleadings, filed with the court in Civil No. 81284 that Mrs. Lum's employment with the Quinn firm, from December 1, 1982, to January 1, 1984, and as Mr. Quinn's secretary from April 25, 1983, to January 17, 1984, included attendance at the firm's case review committee meetings. Confidential discussions occurred concerning case evaluation, settlement evaluation, strategy and tactics between Quinn, his associates, and their clients. Cronin et al. Are attorneys of record for the plaintiffs in Firm v. Honolulu Medical Group, and Ronald P. Perhoff, MD. Quinn's firm, represents the defendants. The case was set for trial on March 1, 1984. According to exhibits attached to the records filed in the instant case, Mr. Cronin recognized the firm's situation and agreed that Mrs. Lum would not be involved in the firm case in her new employment, nor would his firm ever seek to obtain any information from her concerning cases with which she was involved while in Quinn's office, nor would we have her work on any while here. Mr. Cronin goes on to say, in his January 24 letter to Quinn, that Quinn should consult with his clients in the firm case as to whether Quinn's attempt to stop Mrs. Lum from working for the Cronin firm is with their approval. Quinn also alleges that while his firm is known in the Honolulu legal community as one which represents hospitals, doctors and other health care providers, the Cronin firm is known as a plaintiff medical malpractice firm. Quinn lists in several pleadings that on more than one occasion, these firms found themselves adversaries in the same cases. Quinn contends that this action was brought not to bar Lum from working as a legal secretary, or even as a paralegal, since that would be ludicrous given the size of Hawaii's legal community. In fact, Quinn states he would have no objection to Lum's working for any other law firm in Hawaii other than one which specializes in medical malpractice plaintiffs' work, like Cronin's . A subsequent hearing on the original complaint for injunctive relief was then held in Judge Ronald Moon's court on February 6. Plaintiff's motion for a preliminary injunction that would bar such employment for at least 2 years was denied, with the judge noting Quinn v. Lum as a case of first impression. The court explained its decision in light of the standards to be met before a preliminary injunction could be issued, as dealt with in depth by Mrs. Lum's attorney, David L. Fairbanks, who is also the current president of the Hawaii State Bar Association. The standards which must be met in order to obtain a preliminary injunction, as listed by Judge Moon, follow. 1. The court did not feel there was a substantial likelihood that plaintiff would prevail on the merits. If an injunction were to be issued, it would ESSNTIALLLY prevent a paralegal or legal secretary, or attorney from joining any law firm that may have had some case in the past. Cases pending at the present time, or potential cases, which may be worked on in the future. Transcript of the hearing, page 82. 2. The evidence is lacking regarding irreparable damage to Richard Quinn's clients. 3. The public interest would not be served by issuing such an injunction. When an attorney enters practice in the state of Hawaii, he or she agrees to abide and be governed by the Hawaii Code of Professional Responsibility. This code does not attempt to govern the ethical actions of the non-attorneys. While Canon 37 of the American Bar Association's Code of Professional Responsibility, adopted pre-1971, states that a lawyer's skills of a paralegal Quinn v. Elum and Cronin, Fried, Sekiu ampersand Kekina Civ No. 80, 1284 Hawaii Court of Appeals, continued employees have the same duty to preserve client confidences as the lawyer. This canon is not included in the Hawaii Code. Compliance, therefore, with the same rules of ethics guiding the Hawaii attorney, is currently left to the discretion and conscience of the non-attorney. If an attorney in Hawaii breaches the Code of Professional Responsibility, the Office of Disciplinary Counsel may choose to investigate the matter, and may pass the matter on to the disciplinary board and possibly to the Hawaii Supreme Court for adjudication. If an employee of a law office becomes suspect of some breach of ethics or acts of omission, the employing attorney becomes responsible for the employee's deeds. For example, if a legal secretary fails to file the complaint the day the statute of limitations expires, thinking the next day would suffice, it is the attorney who is responsible to the client. The attorney can fire the secretary for cause, but the attorney nevertheless stands responsible. It appears the only way for an attorney to further censor the employee directly is via civil suit for tortious damages. Whether a permanent injunction can or will be granted has yet to be seen in this case. What is clear is that neither the Office of Disciplinary Counsel nor the Hawaii Supreme Court would or could become involved. They have no jurisdiction over the non-attorney working in a law office. Are Section H applicant court opinions analogous sufficiently similar to justify a similar outcome, or result in enacted law any law that is not created within litigation? Law written by a deliberative body such as a legislature or constitutional convention after it is proposed, and often debated and amended, prospective, governing future events, effective in the future. Common law judge made LA/V, in the absence of controlling statutory law or other higher law. Our next concern is as follows. How do you apply an opinion? Of course, an opinion is itself a court's application of rules of law to facts. The Brum opinion, for example, applied California statutes to the facts of a search warrant. How do we apply an opinion to a new set of facts, those presented by a client or by a teacher's assignment? Phrased another way, how do we determine whether the opinion is analogous to your facts? An opinion is analogous if it is sufficiently similar to justify a similar outcome or result. Before covering this theme, we need to briefly examine the two main kinds of rules that courts apply in their opinions: enacted law and common law. Enacted law is any law that is not created with litigation. Enacted laws include constitutions, statutes, administrative regulations, and ordinances. See Exhibit 6.1 in Chapter 6 for the definitions of these rules and who writes them. The verb enact means to pass or adopt a rule after someone has proposed it. The proposal is often debated by a deliberative body, such as a legislature or council, commented on by the public, and by experts, amended, and eventually voted up or down. Most enacted laws are intended to cover broad categories of people or entities, e.g. taxpayers, motorists, businesses. With few exceptions, the reach of an enacted law is prospective. It governs future events that will occur after the rule is enacted. A statute, for example, might provide that after a certain date all motorcycle riders in the state must wear helmets. Common law is significantly different. It is judge-made law, in the absence of controlling statutory law or other higher law such as the Constitution. Common law is created by the courts. It applies to and grows out of litigation involving specific parties. In the main, it covers events that have already occurred, e.g., an automobile accident, and allegedly discriminatory firing. Examples of common law include negligence, breach of contract, and self-defense. See Chapter 6 for other definitions of common law, and for the relationship between statutes and the common law, particularly the power of a statute to change the common law.